Thank you for joining us today for What Every Lawyer and Every Client Must Understand. My name is Dina Blickstein, and I'll be a moderator. I'm a partner at the law firm of Haynes & Boone. My practice focuses on patent prosecution, patent counseling, and post-grant proceedings, as well as I'm a co-chair of our artificial intelligence practice. Joining me today are Richard Claywell, Brand Laundrie, and Darren Spielman. Gentlemen, please introduce yourselves. Let's start with Richard.
I'm Richard Claywell. I'm a CPA, and we do a lot of valuation work. So we get involved with patents, copyrights, trademarks in a number of different ways. We've been doing that for a number of years. So that's my area of quote expertise.
And I'm Brian Landry. I'm a partner at Saul Ewing. My background is computer science, and I have a broad-based intellectual property practice that includes a lot of patent and trademark prosecution, as well as design protection and contentious matters before the USPTO and federal courts.
And lastly, my name is Darren Spielman. I'm a partner at Concept Law Group. We're based in South Florida, but we practice all over the country. Much like Brian, we do all aspects of intellectual property. I focus a lot of my practice on trademark and copyright related topics, but we do everything in the firm. I also do a fair amount of litigation in federal courts and in state courts, as well as before the USPTO. And I am the current chair of the Intellectual Property Committee for the Business Law section of the Florida Bar.
Well, thank you for that introduction, gentlemen. And you can also read more about us on our bios on slides 40 through 43 of the PowerPoint deck. Before we get started, let's say thank you to our sponsors. We have with us Mood, pull the slide up, who is an online dispensary offering high quality products. We have Sunburst Digital, maker of #1 typing application for kids, and Max Asset, a company that helps with asset sales online. For those who are interested, you can also sign up for free weekly newsletter from Financial Poise at financialpoise.com/subscribe. If you're attending this webinar live, you can submit your questions using the web portal. If you're watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Just include the question and the name of the episode, and it will be forwarded to us. Now, before I get started, just final housekeeping issue, our standard disclaimer that this webinar is for financial purposes only. It should not be considered legal, financial, or professional advice of any kind. If you need legal advice, please contact your legal counsel or any of us. And with that, let's get started. So Darren, say I'm a small business owner. Everyone keeps telling me that it's important to protect my intellectual property. Can you help me understand what is intellectual property, also known as IP?
Yeah, so in regular parlance, most people break intellectual property up into, we'll call it 4 topics. That's patents, trademarks, copyrights, and trade secrets. It's easy to break them into those kind of 4 buckets. There's little bits of other parts of the law that seep in and out depending upon what kind of case or what kind of matter you might have or what kind of business issue you're facing. But those are the 4 main ones that most folks, if you called up an intellectual property law firm or a lawyer, that's the 4 topics that somebody should be able to either offer advice for you or be able to help navigate through those kinds of ideas.
And why is IP important? I mean, as a startup, it seems to be an expense. So why should a startup care? Brian?
Yeah, so in an increasingly knowledge-driven economy, IP is often a key consideration and oftentimes the most important asset of a startup company. So adequate protection of that IP can be a vital step in turning ideas from just the mere thought into something that is marketable and is a business asset. Also, it can be something that's really key in securing investment and providing barriers to entry for that block potential competitors from threatening your business.
Right. So it seems like there's a lot of different types of IP. We have copyrights, trademarks, patents, trade secrets. As a business owner, do I need all of them? And how can I tell the difference? Richard?
All right, say it again now.
So there's different aspects of IP, right? You have copyrights, trademarks, patents, and trade secrets. So as a small business owner, how are they different, and do I need all of them?
Yeah, okay, and I apologize. My speakers sometimes kind of go in and out, and I thought I caught the latter part of that. There are multiple different types of intangible assets, and it depends on what it is that you're trying to protect. And from my perspective, and I'm not a lawyer, but we deal in this area. What you're trying to do is protect your interest in some intellectual or intangible property that you own. Within that, you have copyrights, you have trademarks, patents, and trade secrets. These are different classes, if you want to call it, of assets that you would have. And just because somebody has a copyright doesn't mean that they have a trademark, and vice versa. So the copyrights deal primarily with, from my perspective, is something that you have written, a book or musical compositions. Trademark is a unique identity that you've got with a particular company. I think everybody has probably seen the Microsoft emblem with the window with the four parts of it. A patent is something that this is a unique way of doing a particular process or procedure. You have protection for that. And then there are trade secrets, which the way I explain that to clients is that's a secret sauce of how you do something that nobody else really understands how you're doing that.
So it seems to me, as a business owner, I need to be aware of all of these IP protections to keep my business profitable. Let's break each of them down. Let's first talk about what is a patent and what is a patent system. Darren?
All right, so let's talk about the system as a whole. The system is really something that, and we're gonna maybe narrow the idea to the U.S. because in different countries, they got a little bit of different. But the idea behind the patent system is that the U.S. government is going to grant, assuming that it's protectable, is going to grant a right to you, to the inventor of the idea, that gives them a right to exclude others from using, creating, or exploiting that idea. It is the opposite idea of what most people tend to think. Its purpose is so that we can help people innovate, encourage people to innovate, and then be able to disseminate that information, be able to give that information, that technical know-how or how it works or the idea behind it, and publicly put it out there so that in the future someone else can use it in the future. The idea is to encourage innovation, because otherwise someone may not want to create something if they know that it's immediately going to benefit all these other people who might have more means or more resources.
All right, so let me get this right. I have to disclose my idea to the world, and in exchange for a patent, I would get an exclusivity period for a certain time.
Correct.
So how long does it take to get a patent, Brian?
Yeah, so obtaining a patent that is enforceable as opposed to just a mere pending patent application is a multi-year process typically. So it starts with usually working with a patent attorney to identify, are there any bar dates by when the application needs to be filed? And typically the best practice is to file that before you have any sort of public disclosure, sale, or publication of the invention. And then a patent attorney or an applicant will draft an application which includes both claims that act like the deed to one's house and basically define what the potential right to exclude others from practicing the invention is. So in most patent applications, if there's a claim for a widget comprising elements A, B, and C, if a competitor sells something with A, B, C, and D, that would be infringement. But if they only sell A and B, that would not be infringement usually. Additionally, there's a robust disclosure that needs to enable the invention. As Darren and Dina said, there's a quid pro quo built into the patent system where in exchange for a full disclosure of the invention such that other people could eventually practice it, the inventor or the applicant obtains exclusive rights. So it's not enough just to claim the invention, you have to describe it, and that often involves detailed drawings, working examples. So a short patent application might be 10 pages, and certainly in a lot of areas and a lot of inventions, it's not uncommon to see patent applications that are over 100 pages.
And how long does this exclusivity period last?
Yeah, so the general rule is that it's 20 years from the earliest effective filing date. Things can vary a little bit, and sometimes there's compensation with additional term for the USPTO taking longer. Sometimes the patent term can be shorter, but 20 years is a good starting rule.
Okay. So what about, how do I know if my invention is already out there? It seems a lot of inventors say, well, I haven't really invented anything. It's already out there. It's already known. How can one tell? Richard?
I'm sorry, it was cutting up again just a little bit. Say it again, please.
So how do I know if an invention is already out there?
In order to determine if it's already there, what I suggest to clients is they talk with an attorney. They can go to the patent office or trademarks, wherever it happens to be, and there needs to be a search done to determine if you have something that is actually unique and identifiable from other processes that's already been patented that are out there. If there's nothing similar to that, then you can move forward with getting a patent. If you're the second guy on the block that's come up with the idea, then you're not going to get a patent. But you need to in my opinion, get an experienced patent attorney or trademark attorney, whoever you're dealing with, that knows how to do the searches and find this information, so you don't find somebody that doesn't really understand how this works. You spend a bunch of money for them to say, well, I made a mistake, it's already been patented. So that's the first step in the process.
Okay, Darren, so suppose I do research and then I file for a patent. That's called patent pending, right?
That's correct.
All right, Darren, can you tell us what patent pending is?
Patent
Sure. So
pending, you want me or someone else to get that question?
Darren.
Okay, a patent pending means that apparently you've got a unique idea, and they're going to give you, my understanding is some temporary protection on that, and it's going to take a while to process that in order to grant the patent that you're going to have, and it just takes some time to do that. And we'll talk a little later on about the timeline for actually doing that. And in most cases, it's not next week or next month. It takes a lot longer to get a patent approved.
the only thing I would add to that is that there's a period of time that clients like to often do mark on their specific goods or promotional materials that it is patent pending, and that is supposed to only occur after they actually file the patent, not before. There is a way to file what they call a provisional patent, which you then have essentially a year after you file that to actually file the full detailed version. You're supposed to give at least a minimal outline of the disclosure of the general idea behind the patent itself when you do the provisional. And it gives you an extra year to be able to kind of work through it. I'm sure that Brian does this for his clients all the time and maybe wants to expand, but that's another time period. However, that time period is a hard 1 year. And so if you go beyond it and you haven't filed your proper full patent application, again, it could be up to 100+ pages, so it takes time and detail, then you will potentially lose your rights to that idea or invention.
Yeah, just to jump in on that, we often do work with our clients to really use that 1 year period as a chance to. I often describe it as kind of the last best chance, that application we file at the end of that 1 year period, to get any improvements into that disclosure. And the reason for that is after that 1 year, we can file other applications down the road. But because patent applications are generally going to publish after 18 months from that first first priority date, that means that once you file that application around 1 year, you have a publication happening about 6 months later, and many countries outside the United States are what we call absolute novelty jurisdictions. So if there's perhaps a incremental improvement that somebody comes up with at 15 months, it may be much more challenging to protect that than if they fortuitously or through a lot of work manage to come up with that invention at 10 months and then include that in their next application.
So now I'm going to ask a question that every client wants to know. How much does a patent application cost?
Sure.
Start with
Yeah.
Brian and then go to Darren and maybe Richard.
Yeah. So the short answer is it's not cheap, and especially compared to other forms of IP that either don't necessarily require applications and extensive prosecution, or if they do, are several orders of magnitude simpler just in terms of the papers that go back and forth. It depends on the complexity and technology. So for a simple mechanical invention, sometimes is in the $5,000 to $8,000 range. Complex business method or pharmaceutical patents can easily be in the 15 to 20,000. And keep in mind, that's just the initial filing costs. Then there's back and forth with the USPTO, which in most cases is going to have at least one office action asserting that the invention is either disclosed by or obvious in view of the prior art. And additionally, for a lot of our clients, we file internationally because patents have a geographic limitation. So a U.S. patent doesn't give you any rights to exclude somebody from selling your invention in Germany, for example. So it certainly can be expensive. It tends to be somewhat of a gated process, so we can communicate with clients and see if it still makes sense 3 years after we filed that initial application to continue to pursue this. But it definitely is something that you should recognize going in, and as you're planning your company, budget accordingly, because it's not just a one-off cost.
Right. At the same time, this cost is spread over a few years, so you don't have to contribute $20,000 to $50,000 all at once. So how long does it take to get a patent? Richard?
Seems like forever. It could take, well, it's got to go through the process of verifying that you don't have something that's already out there, because the patent office doesn't want to have two patents that are so similar that creates litigation. So you're looking at 2 or 3 years plus, is what I've seen. It's just a long process to get from point A to point B on these things.
Yeah. What's your experience, Darren and Brian?
Yeah,
Sorry, go ahead, Darren.
Yeah, it's years. I mean, it's the government, right? So don't forget, we're still talking about a government agency that is overseeing and reviewing, and it's highly technical. Like Brian said in the beginning, these are sometimes they're really complex, and it's going to take time. And this is not just a quick thing. And when they're offering, you a long-term right, they want to try really hard to get it correct. Doesn't mean they always do, and I'm sure if you put lots of lawyers in a room, they could argue about whether or not that specific patent should have been issued, but it definitely is in the years category and not in the months category.
Yeah, I agree with Darren and Richard. It's certainly in the years category. to put a little bit more nuance on that, oftentimes that's not necessarily a bad thing from our clients. As Dina mentioned, uh, the costs that we talked about, which can certainly be substantial, are not all due on day one. And really, almost all of our clients don't want those costs to be incurred on day one. So oftentimes, our clients are happy to, for example, file a provisional application, have things be relatively quiet for 10 months until we file the next application, and then similarly have things be quiet for a year and a half. There are ways that we can take more aggressive strategies to push things forward, but what we often like to be able to do is not necessarily be forced to do something, which in which case government delay is not a bad thing. And then we can pick our spots and do things to make it go faster in certain directions, so long as we have control over those decisions.
But what does a patent allow a patent owner to do or prevent others from doing? Darren?
So, like we said in the very beginning, it is something that excludes others as opposed to giving you specific rights to make it. It's the reverse of what the logic tells you. Allows you to prevent others from making it, from using it, from even selling it or licensing it. So it gives you the rights to exclude others from all aspects in association with it. That's the goal. That's the purpose of it. And in exchange, you have to disclose it all. That's the trade-off.
Right. And Brian, the patent is good for how long?
20 years generally.
All right. All right. So I think we covered patents sufficiently. Let's move to trademarks. Richard, what's a trademark and how is it different from a patent?
A patent is an invention that you would have, a physical process, manufacturing, for example. A trademark is different in that it could be, again, I mentioned Microsoft a while ago. You have ABC, NBC News. These are symbols that you recognize, that you see every day, but it could be a word, a name, or a symbol, whatever it happens to be, that other people don't have the ability to use. And it's like a patent from the standpoint that once you have a trademark, then you got protection to use that. And I can't emphasize strongly enough that before you go out there, because I've had this happen where people go out with a trademark that they want to use, they start advertising the trademark, and then they find out that it's already been registered. So now you spend a bunch of time, money, and effort trying to promote a trademark that's already on the market. So just make sure that doesn't happen to you.
Darren, can you explain why trademarks are important?
Yeah.
Or why not?
Yeah. I mean, this is my job, right? At the end of the day, what I tell clients when we're talking about trademarks is, look, they're a source identifier. So when you're, walking in the grocery store or walking into any store or even online, and you're looking to buy a certain type of a product, a certain type of a cereal or a cookie, or you're looking to buy a certain type of t-shirt or a pair of shoes, you want to know that what you're buying, if you're buying it from a specific company based upon a specific brand, you expect a certain level of quality or a certain, maybe not great quality, but what you expect a certain level from that type of brand. And you also expect a type of price and maybe even a warranty that comes with it, or a return guarantee, something. But those are the things that are associated with a trademark, so that you can get assurance that that each time I'm going to get that same kind of t-shirt.
What are some examples of trademarks that are well known? Let's start with Brian and then see if Darren and Richard can chime in.
Yeah, sure. So they really can take a wide range of forms. So some include designs, such as the Nike swoosh. And what we mean by different forms is, I think most of us, if actually I'm wearing a pair of Nikes right now, if you saw the tennis shoes I was wearing from the side and just saw the swoosh, many, if not the vast majority of consumers would recognize that and say that's a Nike, even if you didn't see the word Nike. They can also be the product shape in and of itself, so not just a particular design that's on the product shape, but for example, the Coca-Cola bottle has very distinctive curves that many, if not most, consumers would recognize. It could be a simple number. To go back to the 1990s, there was a band by the name of 311. So they either have or at some point had a trademark registration covering entertainment services. And then similarly, to keep it in the sneaker field, go back to the sneaker field, slogans can also serve as trademarks. So for Nike, Just Do It is a well-known trademark. Darren or Richard, feel free to jump in if you got some other ones come to mind.
Yeah,
Sure. Yeah, I guess and these are the other kinds. You are all probably used to seeing regular word marks that you've seen a million times, but some of the other exterior or outside of the norm places, you can also get sounds. So sounds can be a registered trademark. Famously, there's the Pillsbury Doughboy little giggle. That's a registered trademark. So was the sound of the breathing of Darth Vader. Those were registered trademarks. So it's a short clip typically, but those can be registered trademarks for a company. Again, it's the same idea that we said a minute ago. It's about source identification. So if you relate that specific mark, whatever it is, to the brand itself, then that's the goal.
Okay. Richard, anything to add?
well, yeah, I'm sitting here at my desk and we use laptops, and I just happen to look down and I see the word Dell, D-E-L-L, but the E is a little bit slanted. And I think, at least probably everybody in the US, when you see that Dell with that E a little bit sideways, everybody knows that's a computer and they know who makes a computer. So it's just anything that's kind of unique, but you get the protection with it if you get the trademark for it.
So Darren, can you explain what a trademark registration is and what are the advantages?
Yeah, so similar to with patents, you can go to the USPTO and seek a registration. It is a formalization of your rights. In the US, for instance, we recognize what's called common law trademark rights, meaning you're just using it and it's already, associating it with a specific brand or with a specific source. I'm sorry. But in the US, we allow federal trademark registrations. We also allow state trademark registrations, but let's focus on the federal. What it does is it gives you exclusive rights in all 50 states. And that is, unlike patents, that is more of a both sides of the coin. You are permitted to, and in fact, almost required to, you have to actually use it. Unlike patents where you don't have to use the invention, in the trademark sense, you have to use it to prove use. But it gives you exclusive rights across the country to stop others and for you to use it. Some of the unique and nuancy things that we like to talk to clients about is if you're a company selling a product, you can also take that trademark registration and go talk to the folks at Customs and Border Patrol, register your mark with them. And even if you manufacture your product in the US, someone could be manufacturing a counterfeit overseas and still trying to import it in. And if you register your trademark with the Customs and Border folks, they will scan and check containers that are coming in to the US at all different ports. So it's a nice, one of the nice benefits of having a federal registration. Of course, if you have it, you can also go after people using improper domain names, or if you need to take them down on Amazon, for instance. Those are the types of things that registrations are very powerful for now.
Are there any non-legal advantages to registration? Brian?
Yeah, sure. So the trademark register is freely accessible to really anyone that wants to search online. It's also picked up by a number of different services that are more geared towards attorneys. So by registering a trademark, it has a very powerful notice function in that somebody that's looking to adopt a mark would certainly be wise to, and often do, search for trademarks, just to make sure that there's not the situation that Richard talked about earlier, where you spend money investing in a brand and then realize that you have a problem because you arguably infringe someone else's trademark applications or trademark registration. Also, it establishes, just kind of from an evidentiary basis, that you have at least a presumptively valid trademark rights, which, if you're eventually going to potentially need to go into litigation or send a warning letter to somebody, having a registration makes your life a lot easier and quite frankly, a bit cheaper in working with an attorney, because you have something that has a specific date to it and has a government imprimatur, as opposed to trying to prove that you have common law trademark rights. Some other benefits are the USPTO is a really zealous guardian of registered trademarks. So we see this oftentimes when we're filing applications, and the USPTO will cite a previous registration. It may be in a rather different area, different field of use or goods or services, but basically, in our experience, if there's a tie, the USPTO is going to defer to the prior registrant unless and until we reach out to that party and see if we can negotiate a coexistence agreement, which we may or may not be able to get. But in those situations, the USPTO is really doing a lot of heavy lifting for that prior registrant. Oftentimes, in a situation where the prior registrant may not even know about that, they may not even really care about that, and quite possibly may not care enough to engage counsel to oppose it. Those are a couple of the reasons for registering.
Well, I hope everyone understands now the difference between patents and trademarks. But let's switch over to copyrights. Richard, can you tell us what a copyright is?
Copyright is protection that you get for something that you've created, and mentally, I guess. It's not well, it can be a physical item. These are going to be musical compositions. It's going to be plays that are written, movies that are written, literary books and texts that have been written. So you have the right to that material that's in there. You also have the right to determine who can or cannot use that. It is a quote powerful item. I think especially in today's world, where there's a lot of music going on out there, and every once in a while you see where somebody has used the first 8 chords of a musical composition. Somebody wants to sue them for that. And I really don't follow them all that much, but I know that happens. It's out there. So it gives you some protection for that. But it's alluded a while ago that it gives you the right to, i.e., rent it to somebody else. I will let you use pieces of my copyright that I own, and you can use it. I'm going to charge you a fee for that. But you can control who cannot actually use bits and pieces of a copyright, i.e., a musical composition or anything else.
Yeah, I remember Taylor Swift was having an issue with copyright, where she apparently couldn't play her own songs because the copyright belonged to somebody else. But what kind of things can I guess, additionally be protected under copyright? Darren?
So it covers all types of, I would say, expression, art, or artistic works is a way to look at it. So we're talking photographs, or we're talking musical works, we're talking architectural drawings, paintings, anything, all photos and videos and those types of things. We're also talking the written word, or typed. And not a lot of people write these days, but anything that's put down. What's not protected, though, is just a general idea of something, right? So the way that I like to explain it to clients is, look, the idea of the the Romeo and Juliet idea of 2 star-crossed lovers, that general thought process of 2 star-crossed lovers, that's not really protectable. It's the specific things that you start to add in. It's here's the storyline, here's the setting, here's the costumes, here's the character names. It's when you add in enough to make it something worth an actual expression of the idea, an expression of the idea, not the idea itself.
But what about things like software code, right? You can get patent protection on it or copyright protection. How do you decide which one to go with?
We decide based upon how unlikely the patent office is these days to issue those kinds of patents. You can almost certainly get a copyright on software code. And maybe when we get into some trade secrets later, the Copyright Office will even let you treat those as protectable trade secrets, because no one wants to put out their copyright, the source code of their, whatever their next major platform is, for instance. But you can get a copyright protection on source code itself.
What about if I have an idea? I mean, I think, Brian, we said that ideas cannot be copyrighted. Are there instances where an idea can be copyrighted if it's transformed into something else?
Sure. So in copyright, we often talk about what's called the idea expression dichotomy. So to go back to what Darren was saying, the idea would be two star-crossed lovers. But when you start writing that down, now you're starting to put a lot more detail on it. And a key concept, again, for copyright is the fact that you're writing it down. Or in this modern world, if you're typing on your computer, even though you may not recognize it, that's still being saved onto a disk somewhere. And it's that fixation onto a digital or onto some sort of tangible form. That's what is a prerequisite for copyright.
Richard, can you expand further on what a copyright allows a person to do?
Is if I have a copyright, that means I have the right to 100% of all of whatever that I have created. But I also have the right to sparse that out, i.e. give pieces of it to be used by other individuals. And I can determine what that is, how much they can use, the time period that they're going to use that for. I can put any types of restrictions on that, and that's negotiated between you and me what that's going to be. But I have the right to control that and what's going to be disseminated to the public that's coming from you versus coming from me. You can also grant the geographical areas that you're going to use, i.e., do you want to replicate or use my copyright? If it's a country western type of a thing, I may want to just use it in the South, in Texas, New Mexico, Arizona. So I'm going to restrict that those are the only areas you can use that, or other parts of the country. So it gives me the right to be what I call the 300-pound gorilla. I'll let you use it, but here's how you're going to use that. So we have the ability, if we own the copyright, to do that.
Now, previously, we mentioned that trademarks need to be registered for federal protection. Do copyrights need to be registered as well? I'll open it up to anybody.
Yes. So the short answer is no, but there's substantial benefits to registration. So as we talked about, when Dina made the slide deck, for example, for this, copyright existed. But if somebody was to copy the slide deck, it's a prerequisite to either bringing suit or obtaining statutory damages is that the copyright for that work was registered with the United States Copyright Office, assuming it was made in the United States.
Right. So let's drill down a bit further. We have copyrights, patents, and trademarks. What's the difference between all three, say, when it's applied to software code that I used previously as an example? Darren?
Yeah, so I guess it kind of goes with what we said before. So on the patent side, it really is a designed to exclude others, but you don't have to use it. On the trademark side, you have to use it as a brand source identifier and you still get to, in theory, exclude others. On the copyright side, it's kind of in between, is the way I like to describe it sometimes, is you don't have to use it. You also you have to at least use it once because you have to create it once, but you don't have to reproduce it. You don't have to keep using the source code as under your example. But you get to protect it the minute it's created. So unlike the patents or where you need to go through the process of getting the protection in place, you don't need to in order to have a copyright, you don't need, like Brian just said, you don't need a registration. You get the copyright, certainly in the US, you get the copyright merely by creating it and fixing it in that tangible medium.
And infringement looks a bit different between, especially between patents and trademarks, because of that difference we talked earlier about the idea versus the expression. Patent claims are directed to an idea, so maybe a method that includes steps A, B, C, and D, and E, and is it capable of being implemented on an iPhone, for example. But if, let's say, Darren came up with a method that falls within, or a program that performs those steps, even if he never saw my source code, even if he never even saw my patent, that would give rise to patent infringement. Whereas copyright infringement can be a bit narrower in some ways because it requires actual copying, which can be inferred based on access and substantial similarity. So as the copyright owner, I would need to bring in evidence showing that either Darren's code is so similar to mine or he had access such that one could infer that there was copying. And it's not merely enough that his code implements my idea if all I have is a copyright.
So previously we said that copyrights can but don't have to be registered. What are the benefits to registering a copyright? Richard?
Advantages of registering a copyright is it puts the world on notice that this is mine, it's copyrighted, and I anticipate protection under the market for having that copyright on notice. If you don't do that, it gets to be problematic. If you file a lawsuit, if you have it copyrighted, you're in a lot stronger position. My understanding is it goes to federal court for the copyrights. But if you don't have a copyright on it, and I infringe upon you, it's going to be more difficult for you to defend that. It also submits evidence that this is valid. Somebody's looked at this thing and they said, yeah, this is original thought process, and therefore I'm entitled to my original thought process. It also allows me, if I've got this copyrighted and you have infringed upon what I've done, I may be entitled to some damages for that.
So anyone who is practicing in the copyright space knows this term that's work made for hire. Darren, can you explain what it is and when it's used?
Yeah, so it's often used when we're talking about an employee does something for the company and creates a work for on as part of their job, as part of their regular job, and that is often deemed a work for hire. There's a couple nuances that we always caution some of our clients on in that if it is a W-2 employee, a full-time W-2 employee, the company owns the copyright. That employee did the work, but the company owns the copyright on that. If instead, it is an independent contractor, then that contract dictates often what will happen on who owns it. And so, for instance, we always caution, if you hire a photographer or a website developer to go create some work for you, and they're not your full-time employee, technically they own the copyright when they created the work. Now, that's easily controlled if the contract between you and that independent contractor clearly identifies, no, this is either a work for hire or there's other different kinds of languages that I've seen that says, hey, I'm doing this work for you, you're paying me, but you own all the rights. I'm assigning you all the rights. You own all the rights associated with that. And so it's important that there is a clear writing between the parties, because one day if you need to enforce that right as the company, then you have a problem if you didn't actually own it in the first instance because you just didn't have the right contract in place with the independent contractor who you hired.
Brian, how long does the copyright protection last? And we have patents, those last 20 years. Trademarks last as long as they're in use. What about copyright?
Yeah, I feel like I get all the term questions today. So copyright compared to patents is considerably longer. So the short the short answer is between 70 and 120 years. The much more nuanced answer is that it really depends on when the work was made, by whom, and a number of factors. And there's great tables online that will kind of walk you through, like if the work was made or published on this date and these things happen, this is what the term is. To double back to what Darren was saying earlier regarding works made for hire, as the slide notes, that distinction actually makes a difference at the front end. So if you're working with an attorney or filing your own copyright application, it's actually something you need to figure out when you're preparing to file with the Copyright Office, which is not the most fun thing. It's a bit arcane, but it actually has significant legal significance. So it's one of those things where you can't really put it off.
Hey, Darren, I see you nodding. Do you have anything to add?
Yeah, no, I mean there's a technically the Copyright Office and the Patent and Trademark offices allow anyone to file on their own. But there's a very good reason. I always like to say there's a reason why I probably could go look up how to do surgery on my leg, but I'm going to go to a doctor. It's the same reason that, I know it sounds crazy, but that we recommend that you go to whatever attorney you want, but go to an attorney who understands how to file these copyrights. A lot of times it might get registered if I see it happen all the time where it did get registered, but like what Brian was saying is it might have gotten registered with the wrong information, and trying to fix that later is sometimes impossible, or even if it's possible, it's going to harm you in the future when you're trying to enforce your rights, especially if you're in litigation. I just want to add one thing to what Richard was saying on the registration requirement. You are required to have a copyright registration in order to sue. And the only place you sue is in federal court. There's no state court option for you. So you must be in federal court because it is based upon a federal statute. And you can only step into court based upon a Supreme Court ruling. You can only step into federal court with that registration in hand.
All right, so, last but not least, let's switch over to trade secrets, just my favorite topic. But Richard, you seem to be getting all the different bundle of rights questions today. What is a trade secret?
A trade secret in my mind is very, very similar to a patent in that I know how to do something you don't know how to do. And you kind of think about grade school kids pointing their fingers at each other. No, I know better than you do. But the trade secret is not public. I keep it close to my vest. I'm not going to tell anybody what we're doing, how we're doing that. And that's to help eliminate competition. So I've got this knowledge, process procedures, wherever they happen to be, that is not public. And therefore, I don't have a patent for it. The issue with that, and I know we're going to talk about it a little bit later, is if you're going to do trade secrets, be sure that you get non-compete and non-disclosure engagements with your employees. Again, I'm not an attorney. I'm a CPA. We do a lot of valuation work, and this issue comes up all the time where somebody has taken privileged information and used it against their competitor because they don't have a copyright on it. And actually, we had a company years ago where this company just overnight lost 60% of their sales. And the sales manager knew the trade secrets. He tweaked them a little bit, and he went out and started his own business and just really devastated the company. So there are items that I know the process and procedures for, but they're not made public like they are in a patent.
Any examples of known trade secrets that you guys can give?
Yeah, I mean, a lot of times people think of Coca-Cola as the oldest trade secret. Uh, Actually, I believe the oldest one that I'm aware of is the Zildjian cymbal recipe for percussion instruments, which has been passed down from to the first son, I think, going back to the 1600s in Turkey.
That is a long time of keeping something a trade secret,
Indeed, and a very valuable business.
right? Well, what wouldn't happen with patent protection? Which
Yeah.
leads me to the next question. Do I need to register a trade secret? Darren?
No, it's actually the opposite. Is you don't want to. You don't want it public. You need to keep it a secret. And by disclosing it, you undo the value of trying to keep it the secret. The secret, but the second word in that secret is the most important part of it. Is you actually have to keep it that way. So you would never want to disclose or try to register it. With the exception of what I was discussing before, for instance, on the software code, you can submit to the Copyright Office and try to create a copyright for that software code, but the Copyright Office will let you submit very, very small parts of it, enough to show that you in fact do have a source code there, but still keep it a trade secret. You literally designate it in that fashion.
So trade secrets, unlike copyrights, can be litigated in state courts. What are some legal factors the state courts use to determine whether something is in fact a trade secret? Brian?
Sure. So, although there certainly is some variation amongst state courts, there's a decent amount of uniformity, and the factors can really be grouped in, I would say, three buckets. So, one is the extent that the information is known. So that would be, how well is it known outside the business? How well is it known inside the business? So, one example that we often use is, if some piece of information is a particular trade secret, is it something that only certain employees in your business have access to, or is it on some shared network drive where everybody from your sales team to your receptionist can get access to it? That flows into the second bucket of factors, which are the precautions taken by the holder of this trade secret to guard the secrecy of it. So, like I said, is on the network drive. Have you done something to obscure how the trade secret is being used? Say, if it's in a manufacturing process, is there some sort of shield, or can anybody see it when they go driving by the plant? Or if you bring visitors in, does if the mayor comes to see the plant because you're opening some new line, would anybody just happen to see this? And the last bucket is the value of the trade secret. And that can be judged a number of different ways. It can be the savings affected. So if you know, to keep it in manufacturing, if you know this trade secret, does this allow you to create a widget 20% cheaper? Or does it allow you to create a widget that's 20% more valuable for some reason, because maybe it's stronger, or to go back to cymbals, maybe they sound better. How much money did it take to develop the trade secret? Is this something that, to borrow a concept from patent law, is this something that was just obvious to anybody, or did this take a lot of ingenuity and research? And then on the flip side of that, how much time would it take somebody else to independently reverse engineer that trade secret?
Right. Is there any federal protection for trade secrets? Richard?
There are, but the federal government doesn't step in if I, as an employee, disclose something that you have as a trade secret as another private company. So the federal government does not get involved with that. But what they will do is they will give some injunctive relief to people if the individual employee works for the federal government, i.e. now the federal government has just disclosed something that they're not supposed to disclose, then they will step in on those types of cases. But individual to individual, they really don't get involved with that.
So the next question is again what every business owner wants to know. How do I prevent employees from revealing or stealing my trade secrets? Darren?
This is sort of, I think what Brian was saying a little bit ago is what are the, what do you have in place to keep it a trade secret? So if you don't put things in place, you're inviting it. If you're leaving the secret recipe that your entire business is based around, your sauce business or your restaurant, if you're leaving it just in an open notebook sitting in the kitchen where anyone who walks in and out can get it, you're at risk. So one of the things you can do is literal physical locks and keys, actual real locks and keys, or some type of access stop, even if it's a digital lock or whatever it is. You need contracts in place, proper contracts with people who work for you, even independent contractors who understand and recognize. And make sure that it's only being given to people that actually need it. Sometimes you don't even need to give the whole thing to, maybe you need 4 or 5 suppliers of your secret recipe. Well, they don't need to know what the other 4 suppliers are. They only need to know that they're giving you stuff. So it's disclosed only as required and as needed, and put in measures and procedures. That's one of the things that Brian was saying, is that the court's going to look to, what did you do to keep it a secret? How did you stop it? There are laws that are in place. There are, laws that are available. What the federal law does have, though, they do allow a whistleblower exception, so that you can, if you need to disclose something to the federal agency, you can do it in order to basically be a whistleblower. So there's a little carve out, but there are measures in place that you need to take through real locks, digital locks, or even just access. If we're talking about a computer system, don't let someone into those folders. Things that you can do that are easy.
Well, how does a business owner know how to mark something a trade secret? Brian?
Yeah. So it can take a number of different forms. It's not particular magic language. What often will be used is proprietary material belonging to. A key point with that is that trade secret practices are more defensible when it's something that it actually follows the value of the trade secret and the realities of the business. So, simply marking everything a trade secret, to go back, I think it's was Sun Tzu that said, "He who protects everything defends nothing." You'll do much better if it's actually done in a thoughtful manner, and then actually is something where you not only mark the documents, but then you take those other precautions that we've talked about, so that you don't mark it confidential and then just have it out there where anyone can get access to it.
Make a comment about that, and again, this is Richard. I'm not an attorney, but I want to tell you what I think is extremely important here. You have a business owner that's got his friend that lives down the street, got a business, and they want to address a trade secret. So they go to their friend. Well, do you have a trade secret? Yeah, I do. Do you have documents for it? Yeah, I do. Well, just to go on the cheap, can I take a look at what your trade secret documents say? And then I copy those and change them around a little bit. Next thing you know, you've got somebody that has violated that, and the law has changed a little bit, or what they had doesn't really apply necessarily to the particular thing you're trying to protect. So saying that, I would advise the business owners that are watching this, don't do that sort of thing. You're going to get it on the cheap, but it's going to cost you in the long run, because you're going to wind up paying more in legal fees to try to get the error corrected. So don't, come on, guys, don't do it yourself. It's just not worth the pain, trouble, and effort to do that.
All right, Darren, I'll throw the final question out to you. How long does trade secret protection last?
As long as you keep it a secret. It really is that simple. As long as it is maintained as a secret, and then you can treat it and keep it in that manner. Again, secret with the understanding that it can be disclosed to maybe important or required personnel or employees, but as long as you actually treat it like a secret to the public, then it will last forever. I mean, look at some of these formulas or the, like what Brian was saying, the Coca-Cola recipe, or on the slides, it was the KFC recipe. I mean, a long, long, long time. They are, in theory, the one that can last as long as a trademark can. As long as it's trademarks are, as long as it's still in use. But those are the two that could last forever.
All right, so today we learned about patents, copyrights, trademarks, and trade secrets. Any final thoughts for our audience?
I would just say go and consult with a professional, a CPA, or an attorney, or someone who does valuations, or someone who's a proper business advisor who can walk you through understanding the pitfalls of making some of these mistakes.
I'll second that.
Well, thank you so much for joining us today. Thank you to our audience, and also thank you to our panel. Thank you to Richard, Darren, and Brian.